What if you could accidentally delete your own lawsuit? With just one wrong click, one bad piece of advice, your entire case could just vanish. It sounds crazy, right? But that's pretty much what happened in a fascinating legal puzzle that had to go all the way to the Supreme Court to get solved.
So can you really hit undo on a federal lawsuit? You know, one that you yourself chose to end? You'd think the answer is a hard no. But the Supreme Court's surprising answer in the case of Waetzig versus Halliburton, well, it changed the rules for everyone.
So let's talk about the guy at the center of all this, Gary Waetzig. His story starts out as a pretty standard employment dispute, but it turned into this crazy legal labyrinth where one wrong turn nearly cost him everything.
Okay, so here's the play-by-play. Waetzig sues Halliburton for age discrimination. The court says, all right, you guys go to arbitration first. And this is where the critical error happens. Waetzig dismisses his entire lawsuit, thinking he can just pick it up again later if he needs to. Big mistake. He loses an arbitration, and suddenly he's on the outside looking in, asking a judge to please reopen a case that he himself had shut down.
Think about it like this. He didn't just close the courthouse door. He locked it from the outside and threw away the key. Now he's standing there, needing to get back in, and he's hoping the court has some kind of master key, some secret undo button. The problem? A lot of judges didn't even think that button was real. So, how did this whole mess get so complicated? Well, it all comes down to a clash between two little-known but super powerful rules in the legal playbook. Okay, rule number 1 is Rule 41A. This is the I'm out rule. It's what Waetzig used to drop his own case. Now it has this important little phrase attached, without prejudice. That's supposed to be your safety net. It means you can come back and file the same lawsuit again later. But there's a catch, and Waetzig ran smack into it.
And that brings us to rule number 2, the potential hero of our story, Rule 60B. This is the legal system's oops button. It's designed to let a court fix a big mistake and give someone relief from a final judgment, order, or proceeding. Waetzig's whole argument was that his dismissal was a big oops, and that this rule should save him. But the big question was, did his dismissal even count as one of those things?
And here's where it all went wrong, the choice he made. He could have asked for a stay, which is basically hitting the pause button on a video game. The game is still running, you can come back to it later. Instead, he chose dismissal. That's not pause, that's hitting quit to desktop. The game is over. It's gone from the system's memory. It's done. And believe it or not, this entire high-stakes legal battle came down to the meaning of just a couple of words from that oops rule. What does it really mean for something to be a final proceeding? That's it. That was the whole debate. So you had two totally different takes on this. On one side, the 10th Circuit Appeals Court. They said, nope, doesn't count. Their thinking was, for something to be a proceeding, a judge has to be involved making a decision. Waetzig just filed a piece of paper. No judge, no proceeding, no relief. But Waetzig's lawyers were like, hold on, that's way too narrow. When you dismiss a case, it ends it. That sounds pretty final to us. And filing that paper is a formal legal step, so that's a proceeding. And the 10th Circuit really spelled out their position. They basically said, look, a final proceeding needs a judge's stamp on it. It has to be a judicial act. End of story. And that single idea, that clear line in the sand, is exactly what the Supreme Court had to take a hard look at. So you had different courts around the country saying different things. It was a mess. Whenever that happens, it's a signal flare for the Supreme Court. They stepped in to settle the debate once and for all and create one rule for everybody. And their answer? It was a slam dunk. We're talking 9-0, unanimous. Every single justice agreed. They sided with Waetzig. The verdict was clear. Yes, that legal undo button absolutely applies here. So how did they all end up on the same page? It was actually a really elegant bit of legal reasoning broken into 3 simple steps. First, they just looked at the text. The word final means completed. A dismissal completes the case. Simple enough. Second, they looked at the context. The rule says judgment, order, or proceeding. They saw that as a list going from specific to super broad. Proceeding is the catch-all term at the end, meant to cover pretty much any formal step in a lawsuit, including filing a dismissal. And finally, they looked at the history. Turns out, this federal rule was copied from an old California law, and everyone back then understood that it applied to exactly this kind of situation. Case closed. Okay, so huge win for Waetzig, right? He gets his day in court back. But this ruling is so much bigger than just one case. It sends ripples out across the entire legal landscape. So what does this all mean for the rest of us? Well, first, it creates a much-needed legal safety net. People make honest mistakes, and this ruling says a simple error shouldn't automatically kill your case. It also gives us national uniformity, which is huge. Now, the rules are the same whether you're in California or New York. It's also a win for common sense, prioritizing justice over getting tripped up on a tiny technicality. But, and this is a big but for Gary Waetzig, his fight is far from over. All the Supreme Court did was unlock the courthouse door for him. He still has to go inside and win his actual case. And that's really the big question, isn't it? I mean, think about it. He went through all of this years of appeals, all the way to the highest court in the land, just to get back to where he was before he made one simple mistake. He won the right to fight, but after all that, can he actually win the fight itself? We'll have to wait and see.